On May 2, 2022, Politico reported that the U.S. Supreme Court had voted to strike down Roe v. Wade, according to a leaked draft of a majority opinion written by Justice Samuel Alito. The case in question, Dobbs versus Jackson Women's Health Organization, concerns the constitutionality of a 2018 Mississippi state law that bans abortion operations after the first 15 weeks of pregnancy. No draft majority opinion of a Supreme Court decision in the modern history of the court has ever been disclosed publicly while the case was still pending. The court's final ruling is due in June or July. Should the 50-year precedent end, more than half of states could ban abortion if Roe v. Wade is overturned. 13 of them have trigger bans that will take effect immediately. It is estimated that abortion bans in these states will close so many clinics that 18 million women of childbearing age will end up more than 200 miles away from an abortion provider. I'm Liam Clayton. Don't forget to like and subscribe for more content like this. Today I'm chatting with my friend Elise Mallette, a final year law student at McGill University from Mississippi, to get her reactions on the leaked opinion and on the future of abortion law in the United States. Elise, what are the implications of this leak for the Supreme Court itself?
It's not the first and only leak at all from the Supreme Court, but it's the first of its kind. And in that way, it was a big shock for sure that it's a full draft majority opinion that has been leaked. And it is one from February, so it may have already been changed. It may be changed, especially now that the court has the unique perspective, being able to get this preview of what public reactions are. But the fact that it was a full majority draft opinion leaked more than likely by one of its staffers, one of the clerks, is pretty shocking, actually. I'm unfamiliar of any other instance that's like this. There have been other documents that were leaked. Interestingly enough, the last ones that I believe were leaked were surrounding Roe back in 72, 73. But it does really bother me that the court and that Chief Justice John Roberts, from his statement, seem to be more dismayed at the violation of institutional privacy rather than the personal and bodily privacy that they're denying people in this leaked judgment itself. And for me personally, I can't help but feel betrayal at the court's efforts to undermine the integrity of its citizens' fundamental rights.
In the leaked majority opinion, Justice Alito argues that the right to abortion is not among the rights enumerated in the Constitution, and that it is not among the implied rights of the 14th Amendment. What is the counter-argument here?
Yeah, so in his written opinion, Justice Alito asserts that there is no express or implied right to an abortion in the Constitution. And on the one hand, it is correct that abortion itself is not a right explicitly mentioned in the Constitution because, frankly, of course it's not. No medical procedure is expressly mentioned in the Constitution, which brings us to Justice Alito's second point, and that's where I believe he's incorrect. The 14th Amendment contains, just kind of as a little bit of a primer, the 14th Amendment contains what's referred to as the Due Process Clause, which states that nor shall any state deprive any person of life, liberty, or property without due process of law. So this clause contains both procedural rights as well as substantive rights. And the substantive rights is the division that abortion may fall under. It includes a widely agreed upon implied right to privacy, in addition to other areas of the Constitution, but there are no express rights to privacy within the Constitution in the 14th Amendment or otherwise. So what this right actually entails, what the scope of it is, and how far it can be extended is where issues arise. Furthermore, these rights are not absolute, and they can be limited by the state for compelling reasons, also giving rise to various disagreements, of course. So it seems to me that effectively all constitutional rights are premised on bodily integrity and autonomy because, quite simply, none of them could be exercised without it. So to presume that a right to life, liberty, or property would not include a right to exert control over your own body, your own consciousness, and your own physical existence seems deeply and inherently flawed. There's nothing in the Constitution nor in jurisprudence stating that medical procedures, even such critically sensitive ones as abortion, should not be protected in an implied right to privacy. Regarding my previous point about the ability of the state to limit constitutional rights for compelling reasons, in Roe v. Wade, it was argued that the state has a compelling reason to protect the potential for life. I and no one else would disagree with that position at face value. But I would argue that the state clearly has a much greater obligation to protect existing life, i.e. the people, predominantly women, whose lives are threatened by this draft decision. A lot of people also wonder whether this line of argument for protecting the potential for life could be extended to banning contraceptives, which has been proposed in various state legislatures. And some people are going to continue to try to push that. But I strongly question the sincerity behind the motivations for seeking to ban birth control as a way to protect the potential for life when vasectomies are never under fire for the same reasons. This disconnect really highlights the inherently sexist and gender imbalanced nature of these arguments. And I certainly do understand that many people target abortion and certain contraceptives because they terminate a fertilized egg specifically. But even if you believe that begins at conception, an embryo is not a legal person and therefore does not have explicit constitutional protection, unlike the woman who is carrying it, who absolutely does have constitutional rights.
Are there possible implications of this ruling for same-sex marriage or the right to privacy?
Of course, depending on who you ask, a very strong yes or no. But yeah, cases like Lawrence, which upheld the right to engage in private consensual sexual acts, and Obergefell, which legalized same-sex marriage, were cited in this majority draft opinion. They aren't themselves critiqued for being incorrect or wrongly decided or anything like that. But Justice Alito does say that these arguments appeal to a broader right to autonomy and concept of existence, which proves to be too much, which really kind of shakes me reading that, because it just indicates that it's hard for the Supreme Court justice, as well as many other people in the country, to genuinely understand others' existence and their right to an autonomous existence. So while he doesn't directly state that they're wrong, his citation of them as too much indicates a very real and ongoing threat to the rights of LGBTQ plus people in the US. There doesn't seem to be a lot of direct threat to the legalization of same-sex marriage at this stage, because this topic of abortion is so embroiled and is so fiery right now in public discourse. But I remember when I was at work in Houston, Texas, when Obergefell was decided, and my coworkers ran out of work and were the first couple married under this new law, and they came back to work, and everybody was just so happy for them, so overjoyed, and I can't imagine taking that away from them. You know, these really do look like the beginning steps of walking right into a Handmaid's Tale-esque kind of situation where all these rights are being stripped away from people on baseless authority.
When and if the ruling as written in the leaked draft is formally issued, what is the best way to reinstate the right to abortion nationwide?
Well, I think if we leave it up to the Supreme Court, I expect we'd have to wait a very long time, even another generation, another 50 years or so, before it would be willing to reinstate a Roe Casey-like protection of abortion. There is a potential for codifying abortion rights in federal law, but the most recent Women's Health Protection Act just failed in the Senate due to Senator Joe Manchin's vote against it, which is an unfortunately expected result. Manchin did state that he'd be willing to codify Roe, but that this specific bill went too far. And other federal bills are likely to come up, but I'm sure any of them would be difficult to pass. There are also, I think the most promising route at this stage are the private channels that have been established and are being extended every day that Roe is threatened. Luckily, there are abortion medications that people can take now, giving them more options beyond the physical procedure. And it's highly unlikely that these medications will be outlawed anytime soon, because they're used not just for abortion, that's really only the specific combination of medications and the specific dosage that allows them to be used in that way, but they're also used even for things like cancer treatment. And at the same time, the pro-choice group is not anti-life, obviously. It's clearly pro-life, just pro-lives that already exist, basically. I know that there are so many people who, more than anything, just really want to genuinely care for others. They want to provide resources for mothers and babies alike, even a lot of pro-life people. And they don't have to support the people getting abortions in and of themselves, but they shouldn't be in the way of them seeking that out if that's the best option for them, because no one person can know what the best option is for other people. And so supporting each other, giving information, giving resources, having empathy for one another, especially in our own individual decision-making processes about our own physical bodies and medical health, is absolutely critical in conversations like this.